Mediation Act sparks extensive parliamentary debate as government and opposition examine future of alternative dispute resolution. The House of Representatives devoted significant attention to one of the most far-reaching justice reform measures to come before Parliament in recent years. As legislators debated the proposed Mediation Act 2026, the bill seeks to establish Jamaica's first comprehensive statutory framework governing mediation, a process through which disputing parties attempt to resolve conflicts outside the traditional courtroom with the assistance of an independent and impartial mediator. The legislation, piloted by Delroy Chuck, forms part of the government's broader program to modernize Jamaica's justice system, reduce long-standing court delays, and provide citizens with quicker, more affordable methods of resolving disputes. While government members strongly endorsed the legislation as a transformational reform, opposition parliamentarians generally expressed support for the mediation as a principle while urging stronger safeguards to ensure the system is adequately resourced, transparent, and fair. The debate highlighted broad bipartisan agreement that Jamaica's justice system requires meaningful reform. However, members differed on how quickly the proposed framework can be implemented and whether sufficient institutional capacity currently exists to achieve the legislation's ambitious objectives.
People take the opportunity to learn about the principles, practice, and the strategies of mediation, so that whether it is in here, whether it is on the street, if the opportunity of a dispute arises, anybody should really, if they know a little about mediation, assist. So that the idea, as the member from Southeast St. Anne pointed out, mediation is time immemorial.
In the opening debate of the bill, Minister Chuck argued that Jamaica's judicial system continues to face considerable pressure from an accumulation of civil matters that often remain unresolved for several years before reaching trial. According to the minister, lengthy litigation not only places enormous strain on the courts but also creates financial and emotional hardship for citizens and businesses seeking justice. He maintained that mediation represents an internationally recognized alternative dispute resolution mechanism capable of resolving many conflicts without the expense and delays associated with formal litigation. The minister explained that although mediation has been used in Jamaica for many years through various programs and court initiatives, there has never been a single comprehensive law governing how mediation should operate nationwide. The proposed act therefore seeks to establish clear legal standards covering every stage of the mediation process. Among its key provisions are establishing mediation as a recognized legal process across Jamaica, defining the rights and responsibilities of parties participating in mediation, setting professional qualifications and ethical standards for mediators, creating confidentiality protections governing mediation discussions, providing legal recognition and enforceability for mediated settlement agreements, establishing procedures for accreditation, accountability, and professional conduct. Government members argued that introducing certainty and consistency into the mediation process will improve public confidence while encouraging greater use of alternative dispute resolution throughout the country. One of the defining features of the bill is its creation of 3 separate categories of mediation, each designed to address different types of disputes. Community mediation. Community mediation is intended to assist residents in resolving disagreements before conflicts escalate into costly court proceedings. Potential matters include neighbor disputes, family disagreements, property boundary issues, minor contractual disagreements, community conflicts, certain landlord and tenant matters. Government MPs argue that resolving these disputes through dialogue rather than litigation could strengthen communities while reducing unnecessary hostility between parties who often continue living or working together long after dispute arises. Court-directed mediation. The bill also formalizes mediation for matters already before the courts. Judges would have greater authority to refer appropriate civil matters to mediation, where there appears to be a realistic prospect of settlement. If successful, disputes could conclude without requiring lengthy trials, allowing judges to devote more time to criminal matters and complex civil litigation. Government members suggested this approach could significantly reduce the heavy backlog affecting many areas of Jamaica's court system. International commercial mediation. Perhaps the most economically significant component of the legislation concerns international commercial disputes. The government believes Jamaica possesses the legal infrastructure, English-speaking workforce, and geographical position necessary to become a regional center for commercial mediation, serving businesses across the Caribbean and Latin America. Officials argued that creating international recognized mediation services could diversify Jamaica's legal services sector while attracting cross-border commercial activity. Minister Chuck noted that many developed economies are increasingly embracing mediation as a preferred method of commercial dispute resolution because it allows businesses to preserve working relationships while avoiding costly and protracted litigation. Recognizing that legislation alone cannot transform the justice system, Minister Chuck outlined an ambitious national training initiative designed to create a broad network of qualified mediators throughout Jamaica. According to the minister, the government intends to recruit and certify mediators drawn from multiple sectors of society, including justice of the peace, religious leaders, teachers and educators, community leaders, legal professionals, social workers, other suitably qualified individuals. The government believes decentralizing mediation services could make dispute resolution more accessible to citizens living outside major urban centers. Officials also emphasized that certified mediators would be expected to adhere to strict ethical standards governing impartiality, confidentiality, and professional competence. Although opposition MPs broadly supported mediation as an important addition to Jamaica's justice system, several members cautioned that effective implementation will require considerably more than legislative approval. During the debate, opposition representatives raised concerns regarding whether adequate administrative structures currently exist to support the nationwide rollout envisioned by the government. Among the principal issues highlighted were sustainable funding for mediation programs, the availability of sufficiently trained mediators, quality assurance and accreditation standards, ongoing professional development, public accountability mechanisms, geographic access across rural communities, oversight of mediator conduct. Opposition members stressed that establishing legislation without simultaneously investing in institutional capacity could undermine public confidence during the early years of implementation. A recurring theme throughout the opposition's contribution centered on protecting vulnerable participants entering mediation. Members argue that mediation should always remain voluntary and should never become a process through which individuals feel pressured into accepting settlements against their interests. Particular attention was given to disputes involving domestic power imbalances, financial inequality, vulnerable elderly persons, individuals with limited legal knowledge, matters involving broader public interest. Opposition MPs maintain that courts must continue to play a central role in cases where mediation may not provide appropriate safeguards. They argue that mediation should complement, not replace, the formal justice system.
Mediation services, and while I do think there's importance to having persons who are mediating legal disputes which are under the jurisdiction of the court to have some certification, as you've pointed out, and that is already the case. Imposing a new regulatory regime on domestic mediation took me by surprise. I wasn't expecting it when you brought it here. I thought this would have been really focused on being the complement of the arbitration legislation that we have, which really has set the platform for Jamaica to become an international dispute resolution center, with arbitration and now mediation being another arrow in the quiver, so to speak, which would be an enhancement of the overall array of services that can be provided to companies here and abroad and cross-border transactions and so on. So those are my thoughts. I have a concern because I've seen the effect, the chilling effect, the disincentive effect that introducing regulation in areas which have historically not been regulated and aren't really crying out for it.
I want to endorse the comments made by my colleagues. I wish to comment on section 32(1), where it speaks to when mediation commences. What I'm not seeing is for court-referred mediation, whether or not there's a time period for those to be completed. And mediation for me should never become another waiting room in the justice system. And so I think it requires some specificity as to when, especially for court-referred mediations, when this should complete. This, the legislation really is intended to reduce delays and backlogs, and if you don't have a specified time, then there will be the tendency for it to continue without an end. And so it should establish clear expectations of timelines within the legislation. That's my contribution.
Both government and opposition members agree that widespread public education will be essential if the legislation is to achieve its objectives. Many Jamaicans remain unfamiliar with mediation and may incorrectly assume that resolving disputes outside court means sacrificing legal rights. Parliamentarians suggested that comprehensive public awareness campaigns should explain what mediation is, how the process works, when mediation is appropriate, what disputes should proceed directly to court, the legal effect of mediated agreements, participants' rights throughout the process. Without such education, members warn that citizens may hesitate to utilize the new system despite its potential advantages. Should Parliament ultimately approve the legislation, the Mediation Act could significantly change how many civil disputes are handled across Jamaica. Rather than immediately commencing lengthy court proceedings, parties involved in many common disputes could instead pursue mediation as an early avenue for settlement. Examples include neighborhood conflicts, family disagreements, workplace disputes, consumer complaints, small business disagreements, contract disputes, landlord and tenant matters, property issues, certain inheritance agreements. Supporters argue that mediation frequently produces outcomes that better reflect the interests of both parties because solutions are negotiated collaboratively rather than imposed through judicial rulings. In many cases, mediation can also preserve ongoing personal or commercial relationships that might otherwise deteriorate through adversarial court battles. Legal practitioners have also noted that mediation often reduces legal expenses while allowing disputes to conclude in weeks or months rather than years. Supporters also believe that embedding mediation more deeply within Jamaican society could promote a broader culture of dialogue, compromise, and peaceful conflict resolution. The bill will continue its passage through Parliament, where legislators are expected to scrutinize additional clauses and consider further amendments before a final vote. If approved, attention will then shift from legislation to implementation. The government will need to establish accreditation systems, administrative structures, regulator oversight, training programs, and public education initiatives before the new framework becomes fully operational. While government and opposition members continue to differ over aspects of implementation, oversight and resourcing, the parliamentary debate demonstrated broad consensus on one fundamental objective. Jamaica's justice system must become faster, more accessible, and more responsive to the needs of ordinary citizens.
Not a problem. But you see, and let me get straight to that point. Both the member from Southeast St. Anne and also the member from South and Southwest speak of regulation and whether or not certification means we're going to regulate mediators. The truth of the matter is that we want everybody to be a mediator. When you see a quarrel, when you see a dispute, you know, I hope people take the opportunity to learn about the principles, practice, and the strategies of mediation. So that whether it is in here, whether it is on the street, if the opportunity of a dispute arises, anybody should really, if they know little about mediation, assist.
Whether the Mediation Act ultimately delivers that transformation will depend not only on the legislation itself, but on the effectiveness of its implementation in the years ahead. Subscribe today, turn on notifications, and never miss the stories that matter most. Jamaica News Now, your Highlands, your news, right now.